looks like we have most of the attendees have joined. So good afternoon and welcome to our webinar on estate planning basics. My name is Nell Cordick and I am a financial advisor with Bogart Wealth located in McLean, Virginia. In this estate planning presentation, we plan to take a look at some general estate planning concepts and strategies. While there's no such thing as a one-size-fits-all estate plan, I hope that this overview may assist you in thinking about your own estate planning needs, what may need to be updated or changed, and help guide you in understanding of the purpose of the various estate documents. I do have the Q&A open, so if you do have any particular questions, I'll try to monitor that as well as we're going through the presentation. So for those of you who might be new to our firm, our mission is to help clients achieve financial peace of mind by preserving and maximizing intergenerational wealth. A little background on us. We have about almost $2.5 billion of assets under our platform. We're working with over 1,200 households. We are a registered investment advisor firm, which means we are an independent fiduciary advisor working in your best interest. We custody all of our assets at Charles Schwab for your protection, and we are a fee-only wealth management firm. We have 3 locations, our headquarters in McLean, Virginia, and 2 offices in Houston, 1 in Gessner, and 1 in the Woodlands. Bogart Wealth has a team of experienced financial advisors located both in McLean and Houston, and we actually assist clients in just about every state of the United States, and also some folks that are living overseas as well. To support our clients, we have a full operations and financial planning team in our Virginia and Texas offices. We manage our investments in-house and also work with a local CPA firm in Texas to help our clients with their tax preparation needs. So now into the meat of the presentation. What is an estate plan? Simply put, it's a map of how you want your personal and financial affairs to be handled in the case of incapacity or death, and the subsequent implementation of the strategies that will fulfill those objectives. So who needs an estate plan? Chances are you do, we all do. You may think that estate planning is just for someone who has, millions and millions and millions of dollars, but it's not. In fact, an estate plan may actually be more important to a smaller estate as well as to a larger estate. An estate plan is needed for everyone. The fact is, without an estate plan, you cannot control what happens to your property if you die or become incapacitated. Generally, people create estate plans because they want that control. They also want to make sure that their wishes are clear in order to avoid any family disputes. In addition, they care about preserving their property for their loved ones and want to make sure that their loved ones are properly provided for. An estate plan is especially important if you have a spouse that isn't comfortable with financial matters, you have minor children, your net worth is outside of the federal transfer allowable limit. That amount is $12.2 million in 2023. However, it can change. It's subject to, if Congress puts different rules in place, it is subject to changing at some points in the future. Estate planning is also important if you own property in more than one state. It's important if you have privacy concerns and if you have other distinct needs, for example, planning for a succession of a business or something as far as special needs for one of your children. So there are Estate planning concepts that we will be looking at today. We'll be talking first about planning for incapacity, briefly discussing both healthcare issues and property management issues. And when we talk about property management, we're not talking just about real estate. We are talking about any real asset that you may have. Then we're going to talk about planning for death, focusing on first wills and probate, talking about tax basics, lifetime giving, trust, and then the role of life insurance in your estate plan. So first, incapacity. Incapacity actually describes a condition in which you are unable to legally make your own decisions. We're talking about planning for incapacity first because it could happen to anyone at any time. The younger you are, the more likely that you will be incapacitated versus death occurring. Think for a moment what might happen, for example, if you were to become the victim of an accident that puts you in a coma for several months or several years. How would your doctor know what medical treatments you would want or not if you cannot speak for yourself? How would your personal business be transacted if no one is authorized to sign documents for you? What would happen is basically someone else would actually be responsible for making those decisions. And in all likelihood, it would fall to the courts to make that decision. And it would be a guardian that would be put in place. And then in that regard, you would actually not be guaranteed that things would be carried out the way that you would want them to be carried out. So we're going to talk about basically some healthcare directives first, and then we'll talk about handling property management. So you can leave instructions about your medical care that you would want if conditions were such that you couldn't express your own wishes. There are 3 different ways to do this. First, with a living will. Second, a durable power of attorney for health care, which is referred to as a healthcare proxy in some states, and then a do not resuscitate order or DNR. I will also mention that estate laws are very state specific, and that some of the wording and some of the titling of these types of documents can vary from state to state. So first, and someone did have a question that is the presentation available to review later. Yes, we will send you out a link to do the recording, and you will be able to review this later as well. So first, a living will is a document that lists the type of medical treatment that you would want or not want under particular circumstances. For example, your living will might state that you would not want life support if you fell into a persistent vegetative state. With a living will, you'll have to think about all possible scenarios where you would want a specific action to be taken and then put your wishes in writing so that the reader will clearly understand them. A durable power of attorney for healthcare or healthcare proxy lets one or more family members or other trusted individuals who are called agents make medical care decisions for you. Unlike a living will, with this type of healthcare directive, you don't have to envision specific circumstances. You simply grant authority to your agent or agents to make decisions for you, because we can't think of every single thing that may happen at any point in time. Then the do not resuscitate order is used for a different purpose. Let's say that you are in the hospital, lingering and suffering with a terminal illness, and you don't want the hospital staff to take life-saving measures if you suddenly go into cardiac or respiratory arrest. To make sure your wishes are carried out, you may be able to get your doctor to issue a DNR. A DNR is a legal form signed by both you and your doctor that's posted by your bed to give staff members the permission they need to carry out your wishes. Be careful if you are using a DNR. Some states require their own DNR form, and some states require one form if you're in the hospital and a different form if you're in the nursing home. So, just be careful of with different state laws. Some state laws will also require both a living will and a durable power of attorney for healthcare. And that's where, when you are actually asking an estate attorney to write your documents, they will know what is state specific for each of those particular cases. Now let's take a look at some property management tools. There are 3 ways that you can plan to have your financial affairs taken care of for you in the event that you become incapacitated. First, you can arrange to own property jointly, appoint an agent using a durable power of attorney, or third, create and put property in a living trust and name someone to take over the management of the trust if something happens to you. Granting joint ownership of your property to another person allows that person to have the same access to the property as you do. If you become incapacitated, your joint account owner simply acts instead. For example, if you and your spouse have a joint checking account, each of you can make deposits and write checks. So if you were to go into a coma, your spouse would still be able to make any payments necessary on your behalf. The second document is called a durable power of attorney, and this basically lets you name family members or trusted individuals to make financial decisions or transact business on your behalf, just like with the durable power of attorney for healthcare. Now, in terms of, a lot of times you would need a durable power of attorney even if you have joint ownership in a particular property. For example, basically in a property, if you are a joint owner and the property needs to be sold, your durable power of attorney would give the right to sell that property on your behalf. And so a lot of times you will need the durable power of attorney in addition, regardless, even if you have joint ownership. And then basically, in addition to joint ownership and a durable power of attorney, using a living trust is another common strategy. We're going to talk in more detail specifically about trusts later, but a living trust can be used in planning or incapacity because someone called a successor trustee can step into your shoes, manage the property on your behalf or for your behalf if something should happen. So a question came in, is it easier to have a house deed titled as transfer on death? So a lot of times, and we'll talk a little bit more about the advantages and disadvantages in going forward in this presentation, but that is where it's going to be very specific to your specific situation, whether it's better to do it. And it's not only a house deed transfer on death, you can have a number of other asset accounts transfer on death to beneficiaries. And so that is a very specific question to your specific circumstances. And we do recommend talking to a financial advisor and understanding your specific things accordingly. Another question came in. We have a living trust. However, we did not include personal items or household goods that we want to go to specific individuals in it. Can we just create a document to list these goods and items and the designated recipient? Does it need to be notarized? So it does not need to be notarized. And in your will, it will always specify you will have an article that is in the will, and usually it's in the trust also, that will actually address your personal assets. And personal assets are not real assets. They're not investment accounts. They're not IRAs. They're not real estate. It is things in your house, a piece of furniture, a collectible, but something a piece of jewelry that you want to go to somebody specifically, but you don't want to list it out in your will or in your trust. And that's called basically a personal memorandum. The key is that it is dated. It should always say this list supersedes any other list, because just in case you change your mind, you want the final one that is found to be the one that is used. And it just lists the particular item and who it's supposed to go to. I've also seen individuals actually attach pictures so that if there's any confusion, especially around jewelry, that can be a way that there's definitely no confusion. But it is simply you usually keep it with your estate documents, because your executor or successor trustee does have to, usually there is a time limit that list has to be found. So it's important that it's kept with your estate documents as well. So what happens if you pass away without an estate plan? And believe it or not, the statistics are that it's somewhere in an 80% range of people do not have any estate documents at all. And so what happens if you don't have any estate documents? All of us make plans that are based on the possibility that a specific event will occur. Basically, when we are looking at if you don't have a document and it does not have a designated beneficiary, then it will pass based upon your state's intestacy laws. And every state is different. Now, a lot of them do tend to be very similar, but every state is different. And the problem is that it is determined by state law. It may or may not be according to your wishes. So basically, an example, or a very common example that a lot of states adhere to, is that basically 50% of the property goes to a spouse, and then the other 50% is divided evenly among the children. But every state is different. The biggest issue with intestacy is the fact that your actual wishes become irrelevant. Let's assume that you live in a state that has patterned the distribution as we're seeing on this particular slide. So regardless of what your wishes are, this is how your estate would be divided. And there are many potential problems with allowing your property to pass by intestacy. For example, the distribution pattern imposed by your state's laws could result in disputes among your heirs and higher overall taxes due. It can be especially problematic for unmarried couples, because generally intestacy laws do not include an unmarried partner in the distribution of property. And so basically the way to avoid it is to create your estate documents, your will and or possibly a trust. So how many people here have a will? It would be interesting if we could see a show of hands. But basically, the will is the first piece or the cornerstone of your estate plan. So a will is a legal document in which you direct how your property will be dispersed when you die. It also allows you to name an executor who will carry out your wishes, which are stated in your will. In addition, your will let you name a guardian for your minor children. And then in addition, you can create a trust from your will. You can use your will to accomplish other estate planning goals as well, such as tax planning. There's some things that you can do in regard to that. So to be valid, a will must be in writing. It must be signed by you. Your signature must be witnessed, although the number of witnesses will vary from state to state. These requirements are important because if you aren't careful, your will could be invalid. You should have a will based upon the state where your primary residence is. So an estate planning attorney can basically take care of making sure that all of the details are covered, and that you avoid any do-it-yourself solutions that might not have everything covered, and therefore your document could be invalid. Now, there's one big consideration to having a will for some people, and that's the fact that wills generally have to go through a process known as probate. So when we're looking at probate, so first of all, let me kind of explain with a will. Basically, a will is saying, here are my assets, I pass away today, and this is where I want all of my assets to go immediately. If you have any assets that pass by will, that means that they did not have a beneficiary already attached as a transfer on death or an IRA that has a beneficiary. It means it is simply in your individual name. It is not a joint account, and it does not have a beneficiary. If any of those other situations would not have to go through probate, and they would also not pass according to your will. So basically, most wills do have to be probated. The rules vary from state to state, but in some states, there can be an exemption from probate based upon the size of the estate that would be passing via the will. And so probate starts with someone filing the will with the probate court of the city or county in which you live, which will then oversee the estate settlement process. Usually the person named as the executor in the will actually takes the will to the probate office and becomes qualified. Once the will is filed with the court and validated, the executor can then go about the business of settling the estate. This means they will collect any monies owed to the deceased person. They will pay out any outstanding bills. They will file the final income tax and estate tax returns if necessary. And then they will distribute the remaining property to the rightful heirs. Usually everything goes pretty smoothly during the probate process, but it can typically take anywhere from a few months to a year, depending on the size and complexity of the estate. As long as the executor does what needs to be done in a timely fashion and there are no family disagreements. Nevertheless, some people may want to avoid this process, and there are ways that you can avoid probate. So before we look at the reasons of why you might want to avoid probate, let's look at some of the positive aspects of probate. For most estates, there's usually very little reason to avoid probate. So we usually try to say avoid it if at all possible. The actual time and cost involved are fairly modest, and it just doesn't make sense to plan around it if it is a very simple, straightforward estate that would be very easy to settle. Because the court supervises the process, you have some assurance that your own wishes will be carried out exactly as your will states. Further, probate offers some protection against creditors. As part of the probate process, creditors are notified to make their claims about the estate, against the estate, in a timely manner. If they do not, it becomes much more difficult to make their claims later. But looking at the cons of going through probate, for some complex estates, probate can be very burdensome, taking up to 2 or more years to complete. It means that basically the property is tied up and may not be able to be distributed in a timely manner. It may increase costs that arise, such as executor fees, attorney fees, accordingly. And if you have real estate in more than one state, for example, if you own a summer home in Maine and a winter home in Florida, your executor will have to file in each state where that property is located. This is referred to as ancillary probate. And you just don't want to have to go through the process in more than one state. It's difficult enough as it is. Additionally, wills and other documents submitted for probate become part of the public record, which may be undesirable if you or your family members have privacy concerns. If any of these issues are a concern to you, an estate plan can be designed to limit the assets that pass through probate or to avoid probate altogether. The major ways that property is passed outside of probate are, number one, owning property jointly with the rights of survivorship. Second, ensuring that beneficiary designation forms are completed for those types of assets that allow them, such as IRAs, retirement plans, and life insurance, as well as there are certain states that allow you to even transfer property upon death, that you can put a TOD against real estate. And then also by putting property into a trust and by making lifetime gifts. So now we're going to talk a little bit about estate taxes because that's just an important factor that is out there. There are 3 types of federal taxes that may be imposed when property is transferred from one person to another, either during life or at death. Referred to collectively as transfer taxes, these taxes are the gift tax, the estate tax, and the generation skipping transfer tax. So we're going to discuss taxes on the federal level only, but be aware that individual states may also impose their own transfer taxes, and they generally affect smaller estates. It's important for you to get more information on what is state specific of where you specifically live. If you who are considered, so first we're going to talk about the gift tax. If you transfer property to another person during your life, the transfer may be subject to the gift tax. The reason there is a gift tax is to prevent individuals from avoiding the estate tax by giving all of their property away before they die. The gift tax does not apply to every lifetime gift, though. For example, certain gifts are excluded. So in 2023, you can give up to $17,000 to as many individuals as you want, gift tax free, under the annual gift tax exclusion. By the way, that figure is indexed for inflation, and it's been going up. I think it was like $15,000 in 2020 and $17,000 today. In addition, each individual has a lifetime exclusion from all transfers, that's gifts and your estate value combined, and that amount in 2023 is $12,200. Now, that's the largest exclusion that has ever been allowed in history of the federal gift and estate tax, and it very likely will be rolled back in 2026 to a lower amount. It'll be interesting to see what Congress does, but it is in place through 2025. And then basically, when property is transferred at death, it is generally subject to estate tax. This is true whether or not the property goes through probate. For example, even though funds in an IRA will pass directly to a beneficiary, the funds are still part of your estate. As with the gift tax, there are exceptions to the estate tax. For example, property that you leave to your spouse will generally not be subject to estate tax because there's a full deduction allowed for marital transfers. A similar deduction is available for property left to a charity. In addition, as we discussed in the previous slide, each individual has a lifetime exclusion from gifts and estate tax combined 2023, that amount is $12,200,000. And so any portion of the exclusion you use for gifts will not be available for your estate. There's a new feature of the lifetime exclusion that is potentially very important to married couples. This exclusion is portability. That means that any portion of the exclusion that is not used by a deceased spouse can be transferred to the surviving spouse. In prior years, this was not the case. So married couples with larger estates had to do what is referred to as bypass planning, typically using a trust. But beginning in 2011 and then subsequent later years, such planning is not necessary for transfer tax purposes, although there still may be some other reasons to use a bypass trust. But basically, what we are looking at is that a married couple can actually transfer today $24,400,000 without being subject to an estate tax. However, it is very important that when the first spouse passes away, there is a document that needs to be filed with the estate tax return that will claim the portability for the estate when the surviving spouse passes away. The third piece of transfer tax system that we need to mention is the generation skipping transfer tax. In the world of estate planning, someone who is more than one generation below you, for example, a grandchild or great-grandchild, is referred to as a skip person. If property is transferred either during life or at death to a skip person, then the transfer is subject to generation skipping transfer tax, which is imposed in addition to the gift tax or the estate tax. The reason there's a generation skipping transfer tax is to prevent individuals from avoiding estate tax on the intermediate or the skip generation. So basically they're trying to say every generation is going to be subject to the estate tax. Because the generation skipping transfer tax is a separate tax, you get a separate exemption. And the exemption for generation skipping transfer tax is the $12,200,000 in 2023. However, unlike the gift and estate exclusion, the GST tax exemption is not portable. So you can't utilize this for portability purposes. Some key tax figures are adjusted each year for inflation, and you can see how the exclusion and exemption amounts have changed. The Tax Cuts and Jobs Act, signed into law in December 2017, doubled the gift and estate tax exclusion amount and the GST tax exemption to $11,180,000 in 2018. The amounts basically have continued to be inflated, and after 2025, they are scheduled to revert to the pre-2018 levels and be cut by about 1/2. So it is very, even though we're looking at these very, very large exemption amounts today, unless Congress votes to extend them, they will revert back to what they were pre-2018. If your estate is larger than the exclusion or exemption, then it is imperative to do some additional estate planning to minimize the potential impact of the transfer taxes, because in the amount that's over the exclusion will be taxed at the top rate of 40%. So that's pretty extensive in that amount as well. So a couple of questions, I'll just kind of stop right in this minute. What happens if the property is in another country? So there are lots and lots of laws around international ownership of property and whether it counts for your estate here or whether you have to, there needs to be any kind of estate tax paid in the country of where the property is. It is very specific, and it's something that, again, that would be a one-off question, and probably involving an international accountant that is an expert in that country, as well as an international estate attorney that is very much of an expert on those particular laws in that country as well as how it affects here. What is the amount of estate tax that transfers to children? Basically, the exemption today for an individual is $12,200,000 that would transfer to a child and be exempt. If it were a couple, it would be double that at $24,400,000. Does that mean that you can transfer several millions in 2023 and not pay any gift or federal tax? That is correct. So you can transfer, but there are lots of other things that you need to take into consideration if you are transferring that amount out of your estate. The cost basis of whatever property that you're transferring transfers with the gift, but absolutely you do have to file a gift tax form as part of your taxes every year when you do gift more than the $17,000 per person. But that's a very simple form to do. But that's what keeps track of how much you actually are gifting. So when you pass away, that and your estate gets added together to determine what your full value of your estate is at that point. But yes, you can gift very large amounts. You just have to do the gift tax form and file it with your taxes each year. The estate tax rate, the highest is 40%. It is a tiered rate, and I apologize, I don't have that right in front of me, but I can certainly, retrieve that as well. So lifetime giving, that's a lot of what your questions are, right now. Making gifts during one's life is a common estate planning strategy that can also serve to minimize transfer taxes. In fact, transferring property to your heirs during your lifetime has certain advantages over waiting until you die. So for one thing, when you make lifetime gifts, you have the satisfaction of seeing the recipients actually enjoy the gifts while you're still living. For many people, though, gifting is used to minimize transfer taxes. First, as I mentioned earlier, you can actually gift $17,000 to any one person or to any individual you want, and you do not have to file a gift tax return, and it is totally excluded from being part of your lifetime gift exemption. If you are a married couple, you can actually give $34,000 to any individual together. In addition, when you give property that is expected to appreciate in value, you remove the future appreciation from your taxable estate. So that's something that, if you've got something that is going to grow quite dramatically, that is something that could be favorable to go ahead and gift at this particular time. There is one trade-off to lifetime giving, however. Generally, if you give property during your lifetime, your cost basis in the property transfers with the gift. So if you're giving $1 million home that you purchased for $50,000 to your brother, for example, the $50,000 cost basis carries over to the person who received the gift. And that if they end up selling the house, they incur the full capital gain from that particular property. In contrast, if you have property that you are leaving property to your heirs at death, they do get what's called a stepped up in basis to the property equal to the property's fair market value at the time of your death. So if the home that you purchased for $50,000 is worth $1 million when you die, and you had not gifted it, then your heirs get the property with a cost basis of $1 million. And if they decide to sell it immediately, then they don't have to pay an income tax. But it is still part of your estate. So everything has its pluses and minuses. There are always trade-offs. Remember that the annual gift tax exclusion lets you give $17,000 to as many individuals as you want, or $34,000 if you and your spouse make the gift together. If you're contributing to a child or a grandchild's 529 plan for education, which is a type of tax-deferred college savings plan, you can actually give a larger amount directly to the 529 plan, and you can exceed the $17,000 because you're gifting it up front. And then basically you're limited basically with what the gift exclusion amount. There is a limit in terms of for that, but you can give it basically it's 5 years in advance. And then certain conditions apply in each case. Be aware that if you should die during the 5-year period that you've overgifted the 529 plan, they will go back and do a pro rata share of the gift to be included in your estate. But again, a very minor technicality. And then in addition, there's no gift tax imposed for any amounts paid directly to a school or a educational institution for an individual's tuition. And there's also no gift tax imposed on any amounts paid directly to a medical care provider for health insurance premiums. So there are some things that can be done, that you can pay that don't count towards the gift tax exclusion amount. If you are not inclined to make outright gifts, you might consider using a trust. So a trust, and now we're going to get into the whole, advantages of a trust. It is basically very versatile. We've already seen that a trust can play a role in planning for incapacity and in avoiding probate. In addition, you may want to use a trust as part of your overall strategy to minimize transfer taxes, to have certain property managed by a professional, and to provide for minor children, elderly parents, or other beneficiaries. And certain trusts can be established to protect your assets from future creditors of your beneficiaries. Most importantly, though, trusts can provide a means to administer property on an ongoing basis according to your wishes, allowing you to maintain a degree of control after the property is placed in the trust, even after your death. So you hear the common words of saying you're managing from the grave. That's an example of that happening. So a trust is a legal entity where you are the grantor and you are initially usually your own trustee. However, you arrange for another person who would be your successor trustee to hold the property for the benefit of you and ultimate beneficiaries. The grantor names the beneficiary and the successor trustee, and they establish the rules for the trustee. In the trust agreement, it is laid out very specifically what the trustee can do and what they cannot do. When you create a trust, you split the ownership of the trust property. The legal ownership goes to the trustee, and the beneficiary ownership goes to the beneficiary. Now, typically, you are the initial beneficiary, and then ultimately there are other beneficiaries later on. That means that the trustee is legally responsible for managing the property according to the trust rules, and that the beneficiary receives the financial benefits such as income, principal, and the use and enjoyment from the trust property as it is laid out. A trust that you create while you're alive is referred to as a living trust or a revocable trust. A trust that is created upon your death, and if you remember back in one of the very first slides, we said that a will could create a trust. So a trust that is created from a will after you pass away is referred to as a testamentary trust. If you have the right to change or end the trust anytime you want to, then it is considered revocable. If the trust cannot be changed, it is considered irrevocable. A revocable trust generally becomes irrevocable when you die or when you become incapacitated. While we won't go into great detail, and there will be subsequent seminars that we do that go into probably more advanced estate planning techniques, but revocable trusts are commonly used to plan for incapacity and to avoid probate. A trust avoids probate because the trust agreement itself determines what happens to the trust property upon your death. Basically, the beneficiaries are already named in your trust, so therefore nothing has to go through the probate court to be approved accordingly. Life insurance. How does life insurance play into your estate? So basically, life insurance is possibly part of your estate and possibly not part of your estate. And we're going to talk about how it can be both ways that it can be there. So life insurance proceeds sometimes can be the primary financial resource for surviving family members. Life insurance can also be used to provide liquidity for your estate. If an estate has a lot of real estate, then life insurance can be there to provide extra liquidity. And that life insurance proceeds will provide the cash that your survivors need to pay your final expenses, outstanding debts, and taxes. So it can be used for lots of different purposes. You need to be aware, however, that the general rule is that life insurance proceeds are included in your total estate value. Now, recall in the beginning of the presentation that we were talking about taxes on the federal level and that you had an exclusion amount in 2023 of $12,200,000. So keep in mind that part of that $12,200,000 is covering the life insurance amount. Although the general rule is that life insurance proceeds are included in your estate for estate purposes, there is a way to structure life insurance so it is not included in the estate as well. And that particular strategy is called an irrevocable life insurance trust. It is a common strategy. It's called an ILET for short. And basically, the ILET will own the life insurance policy. You do not own the life insurance policy, so therefore it is not part of your estate. So typically what happens is that you will create the irrevocable trust, or you'll create the irrevocable life insurance trust. You will name a trustee. There's a lot of different schools of thought, but I would say let's go with the premise that you should not be the trustee and you are not the beneficiary. And so it is an irrevocable trust because you no longer have control over making any changes to it. The trustee will purchase life insurance on your life, and the policy is actually owned by the trust. And then basically you as an individual will make regular cash gifts annually to the irrevocable life insurance trust. And basically what will happen in that regard is that when you make those gifts, they're there to purchase, to use for the premiums for the life insurance. However, the ultimate beneficiaries do have a right, instead of that premium that you made the gift to be used for the life insurance premiums, they do technically have the right to take the cash instead. So they typically have to be notified by the trustee. They have to sign a letter that they are not taking the money, and they should already be in the loop of what the benefits are to them. So they wouldn't want to take the premium money. And then basically the trustee will then use the funds to pay the premiums on the life insurance. And then when it pays out, ultimately, it is paying out as a tax-free benefit. So basically, the ILET receives, again, the proceeds of the life insurance policy when you pass away. The proceeds are not subject to your estate value. They pass outside of your estate. And they are distributed according to the terms of the trust. Now, many times, an irrevocable life insurance trust will have the same beneficiaries as your overall estate, because the purpose is typically a way, if you've got a large amount of estate taxes that you have to pay, an irrevocable life insurance trust can be a way to reimburse to make the beneficiary whole for having to pay all of those estate taxes. So, in losing out on part of your estate. And that basically then the beneficiaries receive the full proceeds, and there's been no estate tax, no income tax on either side that has to be paid. So as we wrap up, I'd like, just for you to take a few moments and ask yourself, first of all, do you have a plan in place for incapacity? Do you have a will? And if the answer to either question is no, then you really do need to address these issues as soon as possible. And then the second question is to ask yourself as well, if the transfer taxes are an issue for you, meaning is your estate size going to be above the estate limits, then you also need to take immediate action on what you could do to mitigate around paying for any estate taxes. And finally, even if you've already got documents in place, when were they last reviewed? Are they in place for the state that you're currently living in? And do they follow your current wishes? I know, many times we do our will when we have our young children, because we want to make sure that we're providing for guardianship and whatnot. And then we leave it on the shelf, and all of a sudden, fast forward, we're retired. And have we looked at it? Have we updated it in all those years? Now we have grandchildren, great-grandchildren. How are things, and are our wishes the same today as they were when we first wrote those documents? So we do recommend that you update documents probably every 5 years. Laws change, and so therefore it is important that we do update documents on a very, very regular basis. So we do recommend, and we certainly offer, we have a number of advisors in both of our offices, and we would very much welcome the opportunity to meet with you one-on-one and just to focus on estate planning. Every situation is unique. Every individual, every person is individual to their particular circumstances. And that's where we really kind of peel back the layers and go into the documents in detail to determine what types of things are out there. So a couple of questions before we do wrap it up. For a married couple, can both spouses gift $17,000 each to a single giftee? Yes. So if you've got one child and you're a married couple, you could give $34,000 to that child. If I give $17,000 to someone, do they have to file it as some kind of miscellaneous income? No, that's the beauty of this. You can give $17,000 and it doesn't have to be reported on either side. So it is definitely, now do keep in mind, $17,000 is your total gift to that person for the year. Now, is anybody going to come back and really peel back the layers and track oh, I took them to dinner and I bought them dinner and that was $100. Technically, that is considered a gift if the IRS fully audited you. So, again, I've never seen that occur, but that is the rule. And that's why definitely having a partner with your CPA is important. But yes, 17,000, it can be a gift and nobody has to report it on either side. And who does estate planning? Great question. I am not an attorney, so full disclosure, I should have said that at the very beginning. As a financial advisor and having my certified financial planner designation, I have had a lot of education on estate documents, and I've had quite a bit of real life experience with estate documents through my career as a financial advisor. However, I am not legally allowed to write the documents. So an estate attorney must be the individual that writes the documents. But in many cases, I will work with my clients and come up with a checklist of things that you want to be thinking about and put in place prior to meeting with the estate attorney, so that when you get there, you've got things decided and you're ready to get started with the attorney right away. And then, how are financial investments with beneficiaries handled after death? IRA tax exposure. So basically, an IRA typically passes to a beneficiary. The beneficiary can be an individual or it can be a trust. In most cases, it is much more tax advantaged to name your spouse as the beneficiary. And then if you have a trust, the trust would be contingent. But again, every situation is different and we'll look at each one individually. However, think of it this way. The IRS is going to tax someone for all of, if it has to be taxed, they're going to find somebody for it to be taxed to. So an IRA that passes to a beneficiary will be taxed to the beneficiary. Now, there are all kinds of rules. If it's a spouse, it's one way. If it's a non-spouse, it's another. But the beneficiary on an IRA will take over the tax burden. Same thing with an annuity. An annuity has been tax deferred, and so therefore, when it passes, that will be taxed to the person who inherited it. Capital gains, we've already talked about that. That basically, if it's something that has appreciated, it would get a step up in basis, so that's an advantage to the person that's inheriting it. But think about things. If you have to pay taxes on it, there's a good chance that the beneficiary will also have to pay taxes on it. So I think that's all of my questions. Oh, one more. If I understood what you just said correctly, if I pay for all the cost of a family reunion, for example, could that be considered a gift to my children and grandchildren that attend? Technically, yes. I don't know that I've ever seen that be audited. I would run that by your CPA as a question, because they're going to they've seen way more tax audits as a general rule, and they would probably be the best ones to advise you. But technically, if you are paying for someone else something, technically it's considered a gift. But again, I don't think I've ever seen it be audited that way, but I would definitely defer to a CPA's opinion on that one. I think would be very important. So basically, just to wrap up, your estate plan is unique to you. We are here to help. We would welcome you to contact us to request a meeting with any of our financial advisors, both on the presentation as well as on our website. We've got information on how to contact us, both via phone or via email. And we would, be responsive and set those meetings up for you. We do a series of webinars pretty regularly. And so we look forward to seeing you on a future one. Thank you all so much for your time today. And we do appreciate you being with us today. Thank you.